Have you ever wondered what would happen if seven Supreme Court justices suddenly changed the rules of government overnight? Well, that's exactly why legal experts, politicians, and government officials are scrambling right now. A shocking 7-2 Supreme Court ruling has triggered what some are calling one of the biggest constitutional shakeups in years. Behind closed doors, lawmakers are reacting, state governments are celebrating, federal agencies are reassessing their strategies, and yet most people have no idea how massive this decision could become. But here's the real question. What if a single ruling could affect immigration, elections, gun laws, environmental regulations, and the balance of power itself? This isn't just another court case. It's a legal battle that could reshape how laws are challenged, who holds power, and how future political fights are won or lost. So why are some calling this a historic correction, while others warn it could create chaos? Stay with us, because the answer may surprise you. At the heart of this explosive ruling is one simple question. How much power should a single judge really have? For years, federal judges across the country have had the ability to issue something called a nationwide injunction. In simple terms, that meant one judge sitting in one courtroom could block a law, policy, or government action across the entire nation. Think about that for a moment. A decision made by a single judge could instantly affect millions of people, dozens of states, and entire government agencies. Supporters argued this was necessary to stop potentially harmful policies quickly. Critics, however, warned that it gave individual judges far too much influence over national affairs. And that's exactly where the Supreme Court stepped in. In this dramatic 7-2 decision, the court signaled that lower courts may have gone too far. The majority argued that judicial remedies should focus on the actual people bringing a lawsuit, not automatically extend to every person in the country. The message was clear. Courts are meant to resolve disputes, not run national policy. For many legal experts, this represents a major shift in how power is balanced between courts, lawmakers, and government agencies. Instead of allowing a single ruling to freeze policies nationwide, future legal challenges may need to work through the system in a much narrower and more targeted way. Supporters are calling it a victory for constitutional limits and democratic accountability. Opponents fear it could create confusion and uneven enforcement of laws across different states. But regardless of where you stand politically, one thing is certain. This ruling has opened a brand new chapter in the debate over who truly holds power in America. And as you'll see next, the impact doesn't stop with judges. It could dramatically strengthen the role of individual states as well. If reason number one was about limiting the power of judges, then reason number two is about something just as significant: the growing power of individual states. For years, many state governments have argued that Washington was becoming too powerful. They claimed that federal agencies were increasingly making decisions that affected every corner of the country, often without direct approval from Congress. Whether the issue involved immigration, environmental regulations, healthcare, education, or election procedures, state leaders frequently found themselves battling federal authorities in court. And more often than not, those battles ended with nationwide injunctions that froze policies before states could fully implement or challenge them. But this Supreme Court ruling may have changed that dynamic. By limiting the reach of broad nationwide court orders, the court has effectively given states more room to defend and enforce their own laws, while legal disputes move through the judicial system. Supporters of the ruling see this as a major victory for federalism, the constitutional principle that states are not simply branches of the federal government, but independent entities with their own powers and responsibilities. Imagine 50 different laboratories of democracy, each trying different approaches to solve problems. That's the vision many supporters believe the Constitution originally intended. Of course, critics see potential risks. They argue that allowing states greater flexibility could lead to a patchwork of laws where rules differ dramatically depending on where someone lives. What is legal in one state could face challenges in another. What is protected in one region may be restricted elsewhere. That possibility has sparked intense debate among legal scholars and policymakers. But regardless of which side you're on, one thing is impossible to ignore. This ruling has shifted the balance of power in a way that could influence state and federal relationships for years. I come. And as you're about to see, one of the first major battlegrounds where this new balance could be tested is immigration. If there is one area where this ruling could have an immediate and dramatic impact, it's immigration. For years, immigration has been one of the most fiercely contested issues in America. Every new administration has introduced policies designed to either tighten enforcement or expand protections. And almost every major immigration policy has eventually ended up in federal court. But here's where things became controversial. In many cases, a lawsuit filed in one state could lead to a nationwide injunction that stopped an immigration policy across the entire country. One judge, one courtroom, and suddenly, a policy affecting millions of people was put on hold. Supporters of those injunctions argued they were necessary to prevent potentially unconstitutional actions from taking effect. Critics argued that they allowed a single judge to override decisions made by elected officials and federal agencies. Now, the Supreme Court appears to be changing that equation. Under the court's new approach, broad nationwide blocks may become much harder to obtain. Instead of freezing a policy everywhere, courts may be expected to provide relief only to the specific parties involved in the lawsuit. And that might sound like a technical legal detail, but the consequences could be enormous. Imagine two states challenging the same immigration policy. Under the old system, one court ruling could potentially affect the entire nation. Under the new framework, those legal battles may play out more gradually, with different states experiencing different outcomes while appeals move through the courts. Supporters say this restores constitutional balance and prevents judges from acting as national policymakers. Opponents warn it could create uncertainty and inconsistent enforcement across the country. Either way, immigration attorneys, governors, advocacy groups, and federal officials are all paying very close attention right now. Because if this ruling truly changes how immigration challenges are handled, it won't just reshape courtrooms. It could reshape the future of one of America's most important political debates. And the next area that could feel the impact might surprise you even more: gun laws. Few issues create more passionate debate in America than gun rights and gun regulations. And after this Supreme Court ruling, the legal battles surrounding those laws may become even more intense. For years, states across the country have introduced a wide range of firearm regulations. Some have expanded background checks, others have implemented red flag laws, magazine restrictions, or limitations on certain types of weapons. Almost immediately, many of these laws faced court challenges, and in several cases, judges issued broad injunctions that temporarily stopped enforcement while the legal fight continued. These court orders often became major political victories or defeats, long before a final ruling was ever reached. But the Supreme Court's latest decision could change how those battles unfold. If lower courts are now expected to limit their rulings to the actual parties involved in a case, obtaining a nationwide block on gun regulations may become significantly more difficult. That means states could have a greater opportunity to enforce new laws, while legal challenges slowly work their way through the court system. Think about the impact of that for a moment. Instead of one ruling instantly affecting the entire nation, different states may find themselves operating under different legal realities for months or even years while appeals continue. Supporters of the Supreme Court's decision argue that this is exactly how the system should work. They believe elected lawmakers should be allowed to implement policies unless a court finds a clear constitutional violation. Critics, however, worry that citizens could face dramatically different rights and restrictions depending on where they live, creating confusion and uncertainty. No matter which side of the gun debate you support, one thing is becoming clear: the legal shortcut of seeking broad nationwide injunctions may no longer be as powerful as it once was. And if this ruling changes the way gun laws are challenged, the next battlefield may be even more politically explosive. Because the future of American elections could also be affected. If there's one issue capable of igniting fierce political debate almost instantly, it's elections. And according to many legal analysts, this Supreme Court ruling could have a major impact on how future election disputes are fought. Over the past decade, election-related lawsuits have exploded across the country. Battles over voter ID laws, mail-in voting, Ballot deadlines, district maps, voter registration requirements, and election procedures have repeatedly landed in federal court. And in many of those cases, one powerful legal weapon stood at the center of the fight: the nationwide injunction. A single court order could suddenly halt an election rule, affecting voters far beyond the state where the lawsuit was originally filed. Supporters argued that these injunctions protected voting rights and prevented potentially unfair laws from taking effect. Critics argued that they gave individual judges too much control over election policies that should be decided through democratic processes. Now, that balance may be changing, with the Supreme Court signaling that nationwide injunctions should be used far more carefully. Future election disputes could unfold very differently. Instead of one judge issuing a ruling that impacts the entire country, challenges may become more localized and focused on the specific parties involved. That could mean states have greater authority to implement election laws while legal challenges continue through the appeals process. For supporters of the ruling, that's a positive development. They argue that election policies should be shaped primarily by voters and elected lawmakers, not by emergency court orders. But opponents see potential risks. They worry that different states could end up operating under vastly different legal standards, creating confusion during critical election cycles and increasing uncertainty about how voting rules are enforced. One thing is certain: this ruling has added a completely new layer to the already heated debate surrounding election law. And while elections grab the headlines, another enormous area may soon feel the effects of this decision as well. The next battleground isn't about ballots. It's about the environment and federal regulations that affect millions of lives every day. While immigration, gun laws, and elections often dominate the headlines, one of the biggest long-term consequences of this ruling could be its impact on environmental policy. And make no mistake, this is a battle worth billions of dollars. For years, federal agencies have introduced regulations aimed at addressing issues such as air pollution, water quality, energy production, emission standards, and land management. At the same time, states, businesses, and advocacy groups have frequently challenged those rules in court. The result: an endless cycle of lawsuits, appeals, and nationwide injunctions. Time and again, major environmental policies were frozen before they could fully take effect. A single court ruling could halt regulations affecting industries, businesses, and communities across the entire nation. That's why the Supreme Court decision is causing such a stir. If lower courts can no longer easily issue broad nationwide blocks, environmental regulations may remain active while legal challenges work their way through the courts. Think about what that means. Instead of one judge immediately stopping a federal rule nationwide, different states and industries could experience the effects of those policies while legal battles continue. The courtroom may no longer be the fastest route to stopping controversial regulation. Supporters of the ruling believe this encourages elected lawmakers to take greater responsibility for environmental policy rather than relying on judges to settle every dispute. Critics, however, warn that it could create uncertainty for businesses and communities trying to navigate a complex web of regulations. Either way, the battleground is shifting. The biggest environmental fights of the future may be fought less in courtrooms and more in Congress, state legislatures, and public debates. And while environmental groups and industry leaders are already preparing for that reality, another group may be even more concerned. Because this ruling isn't just changing policy battles. According to many observers, it's threatening a strategy that politicians from both parties have relied on for years. Behind all the legal arguments, constitutional debates, and courtroom drama lies a reality that many Americans rarely hear about. For years, politicians and advocacy groups from both sides of the political spectrum have used the court system as a shortcut to achieve goals they couldn't accomplish through the normal legislative process. When lawmakers couldn't gather enough votes in Congress, they often turned to the courts. When state legislatures refused to pass certain policies, interest groups frequently filed lawsuits. And when elections didn't produce the desired outcome, legal challenges became another avenue for influencing public policy. That's where nationwide injunctions became such a powerful tool. Rather than spending years building public support, negotiating legislation, and winning elections, political groups could sometimes achieve immediate results through a favorable court ruling. One judge, one courtroom, one injunction, and suddenly an entire policy could be frozen nationwide. The Supreme Court's ruling appears to challenge that approach directly. By limiting the reach of broad injunctions, the court is sending a message that many legal observers consider historic. Major policy decisions should primarily be made through democratic institutions, not through judicial shortcuts. Supporters of the ruling believe this strengthens democracy itself. They argue that if political leaders want lasting change, they should persuade voters, win elections, and pass laws through the legislative process. In their view, courts should resolve legal disputes, not function as alternative legislatures. Critics, however, worry that some important rights and protections could become harder to defend if nationwide injunctions become less available. That debate is likely to continue for years. But one thing is already becoming clear. The political playbook that both parties have relied on for decades may need a major rewrite. And perhaps the most surprising part of all is that this wasn't a narrow, deeply divided decision. In fact, the next reason may be the most shocking of all, because the size of the Supreme Court majority itself sent a powerful message that nobody can ignore. In today's political climate, finding agreement on almost anything can seem impossible. That's why one of the most overlooked parts of this story may actually be the most important. The Supreme Court didn't issue this ruling by a narrow margin. It wasn't a razor-thin 5-4 decision. It wasn't a deeply divided ideological battle. Instead, the court delivered a 7-2 ruling. And that number matters more than many people realize. When the Supreme Court reaches a decision with such a large majority, it sends a powerful signal to lower courts, lawmakers, legal scholars, and government agencies across the country. Why? Because broad agreement among 7 justices suggests that concerns about nationwide injunctions extend beyond ordinary political disagreements. This wasn't simply one side defeating the other. According to supporters of the decision, it was a recognition that something fundamental had drifted out of balance within the legal system. Think about it this way: Supreme Court justices often disagree on some of the biggest issues facing the country. Constitutional interpretation, federal authority, individual rights, and government powers frequently divide the court. Yet in this case, 7 members reached the same conclusion. That immediately caught the attention of legal experts nationwide. For lower court judges, the message was impossible to miss. When such a large majority speaks so clearly, future courts are likely to take notice. Judges considering similar cases may become much more cautious about issuing sweeping nationwide orders. Supporters believe this strengthens constitutional boundaries and restores a more traditional role for the judiciary. Critics argue that even a strong majority can be wrong and warn that the practical consequences of the ruling remain uncertain. But regardless of where someone stands politically, the size of this majority gives the decision enormous influence moving forward. And as significant as that is, the next reason may be even more important. Because this ruling isn't just affecting today's legal battles, it could completely rewrite the strategies lawyers, advocacy groups, and government agencies use for decades to come. While politicians and media commentators debate the political impact of this ruling, another group is already feeling the effects in real time. Lawyers, and not just a few lawyers. We're talking about state attorneys general, federal government attorneys, constitutional scholars, advocacy organizations, policy groups, and some of the most powerful legal teams in the country. Why? Because for years, many legal strategies were built around one central goal: obtaining a nationwide injunction as quickly as possible. When a controversial policy was announced, legal teams often rushed to court seeking an order that could stop the policy everywhere at once. That strategy became one of the most effective tools in modern legal warfare. A successful injunction could instantly change the political landscape before a case ever reached a final decision. But now, that strategy may no longer deliver the same results. The Supreme Court's ruling signals that broad nationwide relief could become far more difficult to obtain. That means legal teams may have to rethink how they challenge laws, defend policies, and pursue major constitutional disputes. Imagine spending years developing a legal strategy only to have the rules suddenly change. That's the reality many attorneys are facing right now. Instead of relying on one sweeping court order, future lawsuits may require a slower, more targeted approach. Cases could become more localized, appeals could play a larger role, and legal victories may take longer to achieve. Supporters of the ruling argue that this is exactly what should happen. They believe courts should resolve specific disputes rather than serve as nationwide policy-making tools. Critics argue that limiting broad injunctions could make it harder to quickly stop policies they believe are unconstitutional. Either way, legal organizations across the country are already studying this decision and adjusting their strategies. Because what happened here wasn't just another court ruling, it may have fundamentally changed the way major legal battles are fought. And that brings us to the final reason, the biggest reason of all, because many experts believe this decision is about something far larger than lawsuits, judges, or politics. It's about the future balance of power in America itself. When historians look back at major Supreme Court decisions, they rarely focus on the headlines of the day. Instead, they ask a much bigger question. Did this ruling change how power works in America? And that's exactly why many legal observers believe this decision could become one of the most significant constitutional rulings in recent years. At its core, this case isn't really about injunctions. It's not even about immigration, gun laws, elections, or environmental regulations. Those are simply the battlegrounds. The real issue is much deeper. It's about who gets to make the rules. For decades, power has increasingly shifted between courts, federal agencies, Congress, state governments, and the executive branch. Each institution has fought to expand its influence while limiting the authority of the others. Over time, many critics argue that nationwide injunctions allowed courts to become far more powerful than the Constitution originally intended. Supporters of this Supreme Court ruling believe the court is now trying to restore a more traditional balance. Their argument is simple. If lawmakers want to create policy, they should pass legislation. If presidents want to govern, they should operate within constitutional limits. If states want to challenge federal actions, they should do so through proper legal channels. And if courts step in, their role should be to resolve specific disputes, not to govern an entire nation through a single ruling. Of course, critics strongly disagree. They warned that limiting nationwide injunctions could create confusion, inconsistent enforcement, and years of legal uncertainty. That's why this debate is far from over. In many ways, it's only beginning. But one thing is certain. The shockwaves from this 7-2 ruling are already spreading through courtrooms, state capitals, federal agencies, and political offices across the country. The legal landscape has changed. The question now is whether this decision becomes a temporary course correction or the beginning of a completely new chapter in American constitutional history.